Hello, everybody. Good afternoon. This is Joseph Barnett, partner from Wolfstorff Rosenthal, and my partner Richard Yemm on the line. We welcome you to our webinar on L-1 Intracompany Transferee visas, opportunities and updates for corporations. We very much appreciate you attending, and this will be an hour long. We are going to go through our presentation, and then there'll be some question and answers at the end. If you do have questions in the meantime, there should be an ability to ask them through the GoToWebinar application. So feel free to ask questions, and we will do our best to answer them either during the presentation or at the end. And just some small print, like it says down there at the bottom. This presentation does not constitute direct legal advice. It's only for informational purposes. If you do have specific questions or issues related to a case, we ask that you contact your Wolfstorff Rosenthal attorney, and we would be pleased to speak with you and to assist in your matters. Before we get started, just want to give a brief overview of our firm. As you can see at the bottom, we have offices throughout the United States, although we are headquartered in California. Rich and I are at the Santa Monica office, where it is a beautiful 70 degrees and sunny at the beach. So life is good over here. And let's get started. So here's just a brief presentation overview. This is what we're going to be talking about. I don't need to state everything that you guys are reading. But I will say that we have a lot of great resources on our website related to the L visa and all other U.S. immigration and non-immigrant visas, wolfstorff.com. Also, we have a really great YouTube channel. This webinar will be hosted, put up there later in the week, and we have some other really great webinars that go back many years, and we have some great presentations from 2016 about L1s as well, if you want to check those out. Our partner from the Oakland office just did a great presentation about the H-1B registration process. It was a fantastic webinar. And so if you're interested in learning more about that visa, I highly recommend you check that out. So the L-1 is a non-immigrant visa, and it's called the Intracompany Transferee. Intra means within one group, as opposed to inter, which is between two groups. And so the L-1 visa is a great visa to use when you're transferring talent abroad to the United States. And Rich, if you have anything to add, please feel free, but we're going to get right into it. So. Yeah. Excellent. So the Intracompany Transferee visa, it allows someone who has 1 year of full-time employment with a qualifying entity abroad to file a petition on behalf of someone who is in an executive or managerial capacity or who has specialized knowledge, and that individual has worked for that qualifying entity for a cumulative of one of the 3 preceding years before filing the application, and they are seeking to enter the United States to render services to a related entity. And those services that they will be performing in an executive or a managerial capacity or with specialized knowledge. And so, you know, when Rich and I were discussing how we wanted to give this presentation, we didn't really want to go through all of the specific regulations and it be very legalese. Everybody can read the regulations. They can look at the different tests that you are supposed to meet to demonstrate that you're acting in an executive or a managerial capacity. Really what we want to focus on here is the opportunities that are presented with this visa. And what's great is for a manager or an executive, you're able to get 7 years in the United States. And if you're in a specialized knowledge, you're able to get 5 years into the United States. And the way that it works is, unless you're part of a new office, there's a 3-year initial stay, and then you can apply for extensions in 2-year increments. So you can get 2 extensions for a manager or executive and 1 extension for specialized knowledge. And one of the important aspects, and this gets to the intra-company, is it's based on a corporate relationship between a foreign entity and a U.S. entity. And the regulations spell out, what those different types of relationships must be. Is it a parent? Is it a subsidiary? Is it an affiliate? And that's one of the threshold issues that USCIS will be looking at, the qualifying corporate relationship. And as we will explain throughout this presentation, there's very little point in giving, in asserting something without supporting documentation. Whether this goes to a qualifying corporate relationship, whether someone's working in a managerial capacity, either abroad or here, the L-1 these days is, it's absolutely required that you back up every single statement and argument with some sort of supporting documentation. And we're going to get to a little bit more about the statistics, but in general, we're seeing that about half of L-1 applications, according to USCIS statistics, are getting RFEs. That's a request for evidence. That means that the government has reviewed your application and they have some questions that they want you to answer. And we'll get into that a little bit later. But the point I'm trying to make here is that if you don't have supporting documents to back up your assertions, then be prepared for a request for evidence. Rich, let me ask you a question here. What happens in the situation where you are working for a company here in the U.S., maybe you're here on the L, and there is a merger or some sort of acquisition in that company or a restructuring of the corporate organization? What would we need to do with USCIS in those instances?
Hi, Joey. That's a good question. And just really quickly, to introduce myself, my name is Richard. I'm one of the other partners here in Santa Monica. But yeah, in terms of corporate restructure, it can get very complicated very quickly. A lot of times in these kind of situations, particularly if an employee has been transferred from abroad to the company here, depending on how that relationship changes, can very much depend on whether that person still qualifies for an L1, whether they need to file an amendment, whether they basically can't stay there anymore. It really can kind of vary on that front. For example, we've often seen situations where the individual is transferred from abroad to the US, and the company abroad that the actual specific entity that they transferred from abroad is closed down, no longer exists. In that situation, that person's still able to continue in L status as long as there's another company abroad that they could technically be transferred to. So that side of things is relatively straightforward. In terms of a merger, it really depends. You know, if a new company comes in and buys all the entities, probably less of an issue. But yeah, it's one of those things that can vary a lot.
Yeah, sorry to throw, that was a tricky question right off the bat. And I asked it because, just like you said, these are complex issues, obviously based on the facts that are in matter, and you know, something you need to talk with your immigration attorney about. One thing about the 1 year abroad requirement, it must be full-time employment abroad, not part-time, and you must show that is that 1 year abroad is at the time of filing. You need to be physically, you know, the work that you're doing is going to be physically present outside of the United States, and that was put into a memo that came out by USCIS in November of 2018, saying, even if you're being paid by a foreign entity when in the United States, to qualify for an L, your work must be full-time abroad. And brief visits to the United States for business or pleasure is okay. That doesn't interrupt that 1 year abroad requirement. But again, we are going to, and we're going to need to look at, you know, specifically when you're working, how much time you spent in the United States. These are things that your immigration attorney will be looking at. One other point regarding that memo is they gave some clarification on the adjustments of that 3 year period. In the beginning, I said that for a cumulative of 1 out of the past 3 years, you must be in that executive or managerial or specialized knowledge position. And so that 2018 memo gives some clarifications on that 3 year period, depending on, you know, if you're in the United States, on a non-immigrant, on another type of non-immigrant visa, or other scenarios. So there are, in the regulations, there's about 3 different types of L1 categories, but there's also some particularities within them all. There's the L1 executive, which you know, has to do with managing and overseeing an organization or a major department, where you're doing high-level decision-making, formulating policies and framing procedures for those working under you. There is the L1A manager, which can be kind of broken down into 2 subsections, whether you're a personnel manager, in which there are subordinates that are carrying out what the manager is overseeing. And there's also within that category the functional manager, where you are managing an essential function of the organization. There is also the L1B, which is specialized knowledge. That is meaning you have special or advanced knowledge of, you know, a company's products, services, procedures, policies. And based on my experience, this is the most scrutinized type of L application that is out there. And we're going to get into a little bit more specifics after, as I go through these other ones. There is the L1 new office. The L1 new office allows a company to expand to the United States, and you get 1 year to work into the United States, and by the end of that year, you need to demonstrate that the company has developed and grown so much so that there are other workers underneath you that would necessitate you to continue working in an executive or a managerial role. And L1 new offices, I think, receive a lot of scrutiny these days. I would anticipate an RFE on pretty much any new office L1 that we're seeing. And Rich, could you maybe talk about intermittent and L-1 blankets as well?
Sure.
Just briefly.
One quick thing I did want to add on the L1 new office, and if you're preparing a case or if you're looking at potentially doing an L1 new office, I often suggest, I think you can basically Google L1 new office RFE, and it will give you a very detailed kind of breakdown of exactly what they're looking for on those cases. I mean, pretty much you need to show sufficient physical premises, qualifying relationship, all of those kind of things. But that key thing that Joey mentioned is being able to show that the proposed US office will support an executive or managerial position within 1 year. Now, this is something that I've often seen issues with, or immigration can be tough on, is, yes, maybe they'll give you that first year. Maybe they'll give you an L1 new office. You've got a visa. It's good for that 1 year, first year period. But at the end of that 1 year, it's going to be then potentially very tough to get an extension if the company has not grown sufficiently. Because if that company, within a year, which oftentimes, these things get delayed and these problems come up, maybe after 1 year, you don't have the employees, you don't have the structure in place to show that this is a very established business that can support this managerial executive level position, and then you run into issues. So this is something to definitely consider when you're approaching the L1 new office. Again, as Joey mentioned, there's a lot of requests for evidence on those cases, but we're also seeing a lot of requests for evidence on the extension down the line. So even if you do get that approved in the first year, really want to make sure that within that first year, you grow the company, obviously as much as possible, to get it to the point where you're going to have an effective strategy for extending the L. Now, going on to the intermittent L and that side of things, and obviously the blanket. So with the blanket's kind of an interesting one. We often recommend corporate clients that qualify to apply for a blanket L1 approval. And the reason behind this is it just makes it a lot more straightforward, transferring foreign nationals between entities, because instead of every time you want to transfer someone, you having to go through this onerous petition process with immigration here in the US, sending things through to them, filing the entire case to immigration, potentially getting a request for evidence, having to deal with that, deal with additional government fees, all this kind of stuff. With the L1 blanket, once you've been approved for the blanket, that individual can basically just go direct to the embassy or the consulate abroad, and they provide a packet directly to the consulate, and they can basically just be approved somewhat on the spot by that officer. Once they're approved, they get their visa and they come back into the country and good to go. And honestly, we've also seen the adjudication standards at the embassy consulate have been a little bit less tough than immigration here in the US would be. So this is a great option. Now, to give you an idea of what is required, if you're a corporation that wants to look at getting one of these things kind of set up, there's very specific things that they actually want to see in order for you to be able to hit that. And the main one, honestly, there's a couple of different things here that we're looking at. We're looking at making sure that the business has a certain number of actual offices within the United States and abroad, and a lot of other things besides that. The main one that we see it come up the most is this $25 million in US sales. So that's the key. If you have a company that has 3 or more offices and you've got this 25 million 25 million annual sales, you tend to be pretty good. So that's something that maybe we can get into in more detail a little bit later, but I did want to mention that side of things. Now, the way the blanket also works is initially when you file the first application, you file for 1 year. You get the 1 year blanket validity. It's good for that 1 year. Basically, at that point in time, you're providing a list of affiliates, subsidiaries, branch offices, all this kind of stuff. At the end of that 1 year, you then file for an extension. You can basically file an extension requesting indefinite validity. So you can ask for an approval that's going to come back. It's basically going to be valid indefinitely. You don't have to worry about that down the line. Unless obviously there's corporate restructuring, you want to get additional entities added to that blanket. But this blanket, very much the approval will list all of the entities that are affiliated, so that if any of those entities on that blanket approval notice, if you need to transfer individuals between any of those companies, it's very straightforward. It's a case of preparing the application, sending it directly to the consulate. Now, going back to the intermittent, this is one of the exceptions. I know Joey mentioned earlier that the L1A gets 7 years, the L1B gets 5 years. This is one of the exceptions. One exception to that 7-year or 5-year, which isn't really an exception because you're still only getting that period of time, is you can actually ask to recapture time. So if an employee during, let's say they're an L1A, they've got the 7 years, if during that period there's a time at which they were abroad for a significant period, or just, say they take a couple, like a month vacation here and there, and they've got several of those together, they can basically tack that on to the end of that 7-year validity to get their full 7-year time. And we've seen people be able to sometimes really ask for a huge amount of time at the end. The other exception that really is an exception is this intermittent L. And this is where basically in these situations, the 5 or 7 year limit does not apply to those who did not reside continually in the US, or whose employment in the US is either seasonal or intermittent, or if they're kind of only in the US for an aggregate of 6 months or less a year, or residing abroad, regularly commuting to the US for part-time employment. In those situations, you can get what's called an intermittent L, which isn't restricted to this 5 or 7 year limit. The issue here is you do have to be able to provide clear and convincing proof of this, such as arrival, departure records, copies of tax returns, records of employment abroad, all of that kind of thing. The other issue on the intermittent, just to be aware of, is it does not apply if you have alien dependents. So if you as the foreign national are only going back and forth quite a lot, but your relatives, your spouse, let's say, is going to be living continuously in the US in L2 status, then you can't do the intermittent. It's one of the exceptions to the exception on that side of things. But yeah, that covers the intermittent and blanket side of things.
Thanks, Rich. We got some questions here that touch on some of these issues, so I'm just going to dive into the first one here. A foreign parent company has marginal profits, but the U.S. subsidiary sponsoring an executive can support itself with sales and a contract. Will it be a problem? My take is whenever you're doing these applications, you have to demonstrate that both the foreign affiliate and the U.S. entity are doing business. And so they're going to want to see tax returns. They're going to want to see the service or the product that is being provided. It's a little bit difficult to see in this question how many employees are under the U.S. subsidiary that's sponsoring the L1 executive. But I don't think having a marginal profit abroad by itself will disqualify someone from remaining here on an L1. Rich, do you have any other thoughts on that?
No, I mean, one of the things that they do look at is making sure that the petitioner must be doing business in the United States and at least one other country, but that in terms of their definition of doing business is supposed to be meaning the regular, systematic, and continuous provision of goods and services by a qualifying organization, does not include the mere presence of an agent or office of the qualifying organization in the United States and abroad. So in terms of doing business, those are questions that you do sometimes get in terms of making sure that the entity that you're going to be working for in the US is actually, actually doing business, actually has some kind of sales and this kind of thing. And again, Jerry comes back to, you can say whatever you want, but at the end of the day, you need to be able to evidence this. So if you have the evidence that you can provide on that front, I think you tend to be good on that.
Another question we have here is, can you establish a qualifying corporate relationships if the entities are non-stock, non-profit organizations, since there is no stock ownership involved? Okay.
That's a good question. Basically, non-profit organizations they're not eligible for blanket petition, but they are still eligible for individual petitions. Now, on an individual petition, in terms of showing the qualifying relationship, types of things that you would typically show in this obviously would be, meeting minutes, which list stock shareholders, this kind of thing, articles of incorporation, stock certificates, stock ledger, stock purchase. But in these kind of situations, if that's not available, it really is just a case of just seeing what else you have. So if you're able to show articles of organization, partnership agreements, sole proprietorship documents, SEC filings, if there's anything like that, most recent annual reports, all of these kind of things, if you're able to show any of these other documents that list the ownership and really explain that side of things, then you're hopefully able to show that corporate relationship.
Nice. Here's a great question. How do you handle the distinction between executive or manager when the position may qualify as both? And before we even get to that question, let me just, Rich, I'm going to throw you sort of a separate one. Is
sure.
In a situation where a position may qualify for both, what would you suggest? I mean, how would you make the argument that, how would you structure the petition? Do you pick a lane, or do you argue in the alternative, or, what's your strategy in those situations?
I would definitely pick a lane. It's one of these things where I have seen immigration sometimes, where people have been a little bit all over the place. It's like, well, part of my job duty is executive, part is managerial, and then immigration can come back with a crazy RFE basically saying, okay, you're saying you do both, so you basically have to meet both standards. You have to show you qualify as an executive and also as a manager. So I think it's definitely preferred to figure out which one it is, whether it's an executive or a manager. And I know it's kind of one of these situations where, not all positions neatly fit into one of those or the other. I would, again, you'd have to assess the individual case to see, where it's strongest. I think we're probably going to get onto this a little bit later in terms of executive managerial and, the different things that they look for on each of those. But I think it's very much a case of you look at the position, you look at the company overall, and you really want to see what is this position, where is this position strongest? Is it strongest as an executive position or stronger as a managerial one?
Right, and I think USCIS sometimes, whether purposefully or inadvertently, sometimes even combine them. And you'll get an RFE where you're arguing for executive, and they'll come back with saying, well, hey, to show managerial, you need to show X, Y, and Z. And it's like, well, come on, you're not even reading the application here, looking closely at the documents that were submitted. Another thing about RFEs that I see a lot of is this issue of non-qualifying duties. And it can be, I think, a little bit difficult, especially for smaller companies, for an executive to show that you're doing, that you're primarily performing duties in an executive capacity. You're not spending the majority of your time on day-to-day functions, that there are people underneath you that are actually working to produce the product or to provide the services. For smaller companies, the CEO is a lot of times, he's hands-on on everything. He's putting out fires here, he's, helping a manager there. And so it's really, I think, advantageous to give as much information about your day-to-day life. Like, tell me about what you do on a day-to-day basis. Walk me through a typical day. Show me your Outlook calendar. Demonstrate to me, what types of meetings do you have? And one of the biggest things that I find whenever you're doing these applications, you have to explain the who, what, where, why, when. But I think one thing that is missed a lot of the times is how. And in recent RFEs that I've seen, they are asking a lot of how questions. Show me how he has managed or will continue to manage an organization. Show me how the beneficiary has supervised. How will he make decisions on daily operations? That's for managerial. If it's executive, show me how they will direct and the management. How will they establish goals? How will they exercise wide latitude? Those are, that's the job of the immigration attorney and either the executive or the individual in HR who's assisting on the application to really go through that and provide almost like a list of tasks that are needed to be done to complete that duty. And on top of that, show me the supporting documentation that you are carrying out those day-to-day tasks. That to me is an important aspect of responding to an RFE and really RFE prevention. You kind of want to be proactive. If you know what the RFEs, what they're looking for in the RFEs, you kind of have to take that into consideration when you're putting together the initial application.
Yeah, and just to add really quickly to that, I've seen a lot of requests for evidence asking for a percentage of time that you're doing each job duty. And this is something you can sometimes avoid the request for evidence by making sure you include that as part of the initial application. Because again, where Joe was talking about, there's sometimes where there's some duties that don't qualify. But if you're able to show that at least the majority or most of your job duties are kind of within this directing the management, establishing the goals, or doing something along those lines, if you give them percentage stuff, that often tends to help quite a lot.
Great. One other thing that I wanted to mention is if you are in an L-1B specialized knowledge and you are moved to like a managerial role, it is possible to get an extra 2 years into the United States. So just because you are always in one category doesn't mean you always have to be in that. You can move it around as long as it's supported appropriately. One thing before we move on from this slide, we've been on it for a while, is sort of the difference between special knowledge and advanced knowledge. This gets to the L-1B. The way that I like to think about it is advanced knowledge has to do more with an employer and their processes and procedures, whereas special knowledge has to do with industry specific. You know about products and services or researchers or technology in an individual industry, whereas with advanced, it's more about proprietary work product. Maybe you are, doing training or you've created the actual process and now you need to transfer that person over to the United States to continue working in the to continue working here in that sort of capacity. All right, let's move on. We're going to be quick here. Just the key advantages of the L-1. I think this is a great way to transfer people over. What's great about it is that there are no, annual visa restrictions. There can be as many visas given out under the L category as possible, unlike the H-1B or H-2A, H-2B, where there's certain quotas, or with immigrant visas where there are caps on the number of folks who can come in. Another great thing about Ls is that for certain situations, for key personnel, you can sponsor for a green card under the EB-1.3 or EB-1C, which is the green card equivalent of the L-1. In those situations, I think they usually want to see a bigger business. They want to see larger revenue. And for the employee, what's great is, you're coming over with your spouse. What is she going to be doing? What is he going to be doing? Well, once you get into the United States, they can apply for an EAD, and they have unrestricted right to work. With that EAD, a spouse and a child get an L-2 visa. They can apply at the same time as the L-1 visa holder at the consulate. Children cannot work, but they can go to school. And like everything else in immigration, that L-2 for the child is good up until the time that the child turns 21. And Rich, can you explain just a little bit about the concept of dual intent and how that can help folks when they're traveling in and out of the country?
Absolutely. So a lot of non-immigrant visas are not dual intent. And what I'm basically, with visa types that are not dual intent, the idea is you cannot have the intention to be filing for a green card at the same time as coming in on that non-immigrant visa. Now, the L-1 visa is a dual intent visa. What that means is when you're coming in, you can have the intention to stay permanently, but also to come in somewhat temporarily on the L-1 visa. So what this can be really useful for is if down the line, the company wants to file a green card for someone, that person can technically continue to travel on the L1, even with the green card pending, and they're not going to get questions, when they're coming in, the officer's not going to ask, or even if they do ask if you've got a green card, it's not going to matter. It's still okay to be traveling on the L1, to still have an L1, and have a pending green card. So this can be really good just moving forward.
Excellent. Rich, are you feeling a little cold?
A little bit.
Yeah, because I think it's time to bundle up and get cozy with a little bit more blanket L's. What do you say?
I think we
should. That was really lame, but anyway. All right, so I know you talked earlier about the blanket L's.
Yes.
But maybe you can just go into it a little bit more detail on how it can save time and money and the headache of dealing with USCIS.
Sure. So yeah, again, kind of went through a lot of this earlier, but yeah, I mean, if you're a company that has 3 or more domestic branches, office in US doing business for 1 year, evidence of either at least these 10 L managers within the last 12 months or 25 million annual sales, which is what we tend to go for, or US workforce of at least 1,000 employees, then you as a company can apply for this L blanket approval, which gives you that ability to send potential transferees directly to the embassy or the consulate to actually apply for the visa directly there. So this is a very useful thing, and it makes the whole process a lot quicker and easier for a company that qualifies under this. One thing to add on this, I don't think I mentioned earlier. So the L1A, similar situation on the blanket. The L1A, you've got to be able to show you've worked as an executive or manager abroad. Your position here in the US is also going to be executive managerial, which we'll get onto a little bit later. But in terms of L1B, now there's one slight difference on this. In the blanket context, the L1B has to be a professional. So we've got to be able to show they've got at least a bachelor's degree or equivalent in order for them to qualify under the L1B. So this sometimes can be an issue. If you have someone who may have specialized or advanced knowledge, but doesn't necessarily have a bachelor's degree, but if they have enough experience that you can kind of get that equivalency done to show that it's the equivalent of a bachelor's degree, then you can still be okay. So that's one thing I did want to mention that we may have missed earlier.
Great, and I would just say in general, I think the big benefit here, especially for those who are like on short notice, are being transferred, is that there's a lot less, I think, scrutiny by a consular officer than if you're going to be doing an application with USCIS. I think just in general. And now there is the ability to file premium processing for L1 to get a decision within 15 days. But if you got the blanket, you don't even need to wait that time. You just head over to the consulate right away with your copies of the I-129S, and you're able to get in very, very quickly. Rich, anything else to add on blankets?
No, I think that pretty much covers it.
Okay. We're going to talk just briefly about green card options for L-1 employees. This is what I was sort of saying before, the EB1, EB13, EB1C. This is filed on an I-140. There is no premium processing allowed for the EB1C right now. But it's pretty much the similar type of qualifications as there would be for an L1 or an L1A executive or manager. There is no green card option for a person with specialized knowledge. And then the EB2, EB3, this is what we call PERM application. There's nobody in the United States who's qualified to do the job, and this is a process that involves the Department of Labor. There is premium processing allowed on the I-140 after the PERM labor certification process is approved. And this also gets to the point that I was saying before. On the L, there are no visa number restrictions. But for green cards, there are. And so every month, the Department of State publishes a visa bulletin indicating whether you are able to move forward and apply for an immigrant visa or apply for adjustment of status if you're in the United States. And what we have down at the bottom of this page is the February visa bulletin. There's the chart B, date for filing. So soon after the Department of State publishes the visa bulletin, USCIS will indicate on its own whether or not folks who are lawfully in the United States may file an adjustment of status at an earlier time than one would be able to apply for an immigrant visa. And you can see that for EB1, except for China and India, anybody else, any national of any other country would be able to apply for an adjustment of status soon after their I-140 is approved. That can be a great benefit, prevent traveling back and forth. You can see here with EB2, EB3, specifically EB3, there is a backlog for all countries. But again, this is something that you want to speak with your immigration attorney about, either from an HR manager point of view or the employee point of view, to have a short-term immigration strategy along with a long-term immigration strategy and taking in mind the goals of the business as well. And that's something that we are very keen on doing here at Wolfstorf, is making sure that we have an entire immigration strategy for all employees. Rich, do you have anything else you want to add to this?
No, I think that's about it.
Okay. So you may have heard that soon after President Trump took office, he started really ramping up immigration restrictions. And one of them that he put forward is the Buy American Executive Order. We call that BAHA, putting American workers first. And this is a key aspect of L-1 adjudications these days. He was sort of brought into office on somewhat of an anti-immigration campaign and making sure that U.S. workers are protected. So in every application that I submit to USCIS these days, in particular for Ls, you have a paragraph explaining how this individual's presence in the United States will benefit U.S. workers, will benefit the U.S. economy. And this has also been placed into the Foreign Affairs Manual, which is sort of the source of regulations for consular officers as well. The fact that you're supposed to be looking at visa issuances for L-1 employees with the idea of Baja in mind. You know, one of the biggest things I think on a day-to-day basis is this rescission of deference to prior approvals for extensions. So in the past, you know, you were granted an initial 3-year period, you remain in the same job. It was relatively simple to say, look, I'm going to be continuing to work in that position. These are my duties. Here are the taxes. And you don't have to submit everything that was previously submitted in the initial application. Nowadays, every time I file one of these, we submit the full application all over again. My L applications are usually 3 to 6 inches thick of supporting documents. And, you know, this is all in the hopes of protecting, preventing fraud, and making sure that, you know, people are not abusing the immigration process. There were always site visits that happened with Ls, but site visits have really increased. We're going to talk a little bit more in detail about that in a couple of slides. Oh wow, I realized we're already at 11:45. Okay, let's keep going. Oh, this happened so quickly. So why is my immigration attorney asking for this? The reason why is because USCIS is asking for it. And this gets to one of the questions about how you respond to an RFE where they throw you the kitchen sink. The kitchen sink is really the boilerplate RFE. It's as if they never looked at your application in the first place, and they are telling you, hey, can you just submit that all over again and explain even in more detail why you believe this employee qualifies for the visa. Like it says here, for public companies, I think it's more regarding the actual position, the job. For smaller companies, I think it has to do more with the qualifying relationship, and also making sure that that no non-qualifying duties are being used for the majority of the employees' time. In the past, you know, we could get employment verification letters, and that would suffice to demonstrate someone who is working abroad. Now they're asking for pay stubs, they're asking for extensive corporate documentation, and they're asking for it in every single extension as well. So my goal whenever I have a new client is to get as much information up front, because that information is going to stay the same. And you know, you're going to have to just keep on sending that into USCIS every single time. For HR managers, you just need to know that when sponsoring someone in an L these days, there are going to be some additional costs responding to RFEs. Importantly, one of the things that is critical here is it relates to payroll and how the employee gets paid. There is nothing in the regs that require that the individual who's working in the United States is put on the payroll of the U.S. company. So it can be the foreign affiliate can pay for the U.S. employees' compensation. But with regards to Baja, what they want to see is that you know, you're not undercutting what U.S. workers would be making. And so it's important to provide the full compensation package when you are demonstrating, in particular to a consular officer, you know, how you're going to be getting paid. And so, you know, are you getting any relocation allowances, travel allowances? Those types of things are very important, and it's critical that the employee can accurately describe all of the compensation package that he's getting.
One thing just to really quickly jump in on this in terms of requests for evidence, sometimes more regarding the blanket. In the past, it used to be very easy to show which companies were affiliated. And I think we had a question on this, being able to show which companies were under the parent company. You know, you show your Form 10K and your report lists all of the subsidiaries. The SEC no longer requires companies to list those subsidiaries on that Form 10K anymore. And that typically means that companies don't do it. This makes it a little bit tougher to really be able to show, you know, which companies are associated, which companies are affiliated to that main entity. So one thing that you can use instead is a certified attestation from appropriate authorized representative. So we call it a certificate of corporate affiliation. So basically this would be where someone who's able to sign on behalf of the company is basically signing an attestation to say, you know, look, I'm in a position to know, I'm, you know, senior, whoever it is, vice president of finance or whatever it is with the company, can sign off on this document to basically say that all of the entities on the listed document are affiliated. And immigration's been pretty good at actually accepting that as evidence in situations, particularly with huge multinational presence where there's, you know, 200-300 different entities, and it's going to be a tough one to actually go into each and every one of them and show qualifying evidence and everything else for every single company. And this has been something they've accepted on that front. So I just wanted to throw that in there before we move on.
Excellent. Thanks, Rich. This just has to do with financial planning. Right now, the fee to file the I-129 is $460. There has been a proposed rule that would increase that to $815, a 77% increase. And like I mentioned earlier, more RFEs than ever before. USCIS says it's up to over 50% of L1s get RFEs these days. But you know, what we wanted to kind of explain here is that there still are, you know, there are costs associated with doing an L1, but there's also a lot of savings that can be involved or related to keeping, you know, important folks within an organization, whether it's, you know, the competitive edge or reduced internal trainings, having that institutional history. That are all benefits that come along and can outweigh the L1 costs, especially for those who are in the high-level roles. All right, L1 audits. This has also increased ever since BAHA was passed. In fiscal year 2019, there were over 12,000 L1 site visits. 8,000 of those were targeted site visits, and 4,000 of them were random. Based on what I've seen is that a lot of the targeted site visits have to do with off-site workers where they're at a third-party location and making sure that they're actually doing the work there.
I've seen a lot of these extensions as well. A lot of times if you've got one approved and then you file the extension, shortly after that extension has been approved, you may see a site visit to your location.
And so it's really important to have an audit plan and to retrain your receptionist or whoever's working in the front area how to interact and respond with someone from USCIS, because they're usually removed from immigration matters. So there should absolutely be some sort of strategy that is created. Work with your Woolsworth attorney to create that. I think one of the key things is keeping a copy of the L1 petitions that have been filed with USCIS separate from other personnel documents. You know, what they're going to be asking for, they're going to do a physical inspection. They may interview employees on their job duties, their work hours, where they're working. how much they're making, so again, it's incredibly important to be prepared for that. A lot of times they're voluntary, but our advice is not to shut them out. I think if you do that, you're likely to receive either a very difficult RFE or a notice of intent to deny, or even a notice of intent to revoke the approval of a previously approved L-1 petition. So the L-1 visa interview, we've kind of talked a bit about this, but there are different places where you can apply. Like we mentioned, USCIS seems to give the most scrutiny. Rich has talked about applying at a U.S. consulate or embassy after the L-1 blanket is approved. And for Canadians, you can apply for at a port of entry, although there are some exceptions to that. Rich, do you want to talk a little bit more about that?
Yeah, I mean, we don't have a huge amount of time, but in terms of Canadians, you know, when they're applying for admission on an L1, they can basically provide the documents kind of basically at pre-flight inspection and make an application there instead. So that side of things can just make things a lot easier than having to go through the whole visa process because Canadians are visa exempt.
Okay, so again, this also talks about this next one. We're going to finish up soon. Just sort of an update on applying at a U.S. consulate after your L-1 application has been approved by USCIS, or if you're able to qualify under the blanket. It's been our experience that, you know, larger consulates like London or Tokyo, Brazil, Europe in general, even in Mexico, that have a lot of experience with L1s, they tend to be a little bit easier to get the visa issued as opposed to smaller posts. For example, the purple dots, if they're in South America, or in Africa, where they may just not have as much experience and maybe a little bit more unpredictable. We have heard that in India, in particular Chennai, there are L1Bs are very, very difficult. L1As are a little bit more successful. But there and Singapore and the Philippines, I think there's a lot more scrutiny on those types of applications because of a lot of fraud that seem to occur in those areas of the world. One other thing that kind of speaks to the Canadian issue is, you know, processing renewals at the border. For a while they were doing that and then they just stopped. And so now you must file with USCIS or apply as a third-party national at posts like Berlin or Dublin or Barbados, where they are able to process Canadian renewals. So again, where you apply does matter, and it's important for your employees to know why they were chosen for the role, how their knowledge differs from others in the company, how their skills may differ from U.S. workers who cannot perform this type of task. And Rich, do you have any other final parts before we get to the questions? I know I think we're pretty much at 12 o'clock, but maybe we'll stay on for another 5-10 minutes and answer any questions. If you have any, please feel free to write them to us.
No, I think that's about it. I know we've got a couple of questions here about if an executive in the US has been working for the last 4 years from Canada but paid by US HQ, can he qualify for L1A if they have other foreign entities? My answer would really depend on what company he was working for abroad. If you know the company actually has an entity abroad and that individual while he was abroad, even if being paid from the US, was actually working for that entity, then that could be a possibility. But you can shoot me an email on that. We can go into it in more detail. think that seems to be about it. You've got my email address there, and obviously Joe is there as well. Do you see any other questions you want to go through?
No, I think that should be it. I mean, I guess the only other thing that I would say in this day and age where USCIS seems keen on denying applications and restricting legal immigration as much as you can, I think it's important to not only think about responding to the immigration officer, but also thinking about writing a federal judge. Who is the audience of your response? And if they are going to deny, then it may be appropriate to file a lawsuit against USCIS and have a federal judge rule that their decision is arbitrary and capricious or abuse of discretion, not in accordance with law. And so always have that in the back of your mind when you are responding to USCIS. So we thank you very much for joining our webinar today. Again, this will be put up on YouTube sometime soon. If you guys have any specific questions, Rich's email is at the bottom, my email is at the top, and we will be happy to speak with you. Thank you so very much, and have a wonderful day.